Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 169 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I've been hosting this podcast since August 2014, bringing you all things employment law and HR related, including best practice, hints, tips, and an update on the law as and when it changes. For those of you who are regular listeners, you will know that myself and my team produce quite a lot of free content for you, both online, via the podcast, and also on our YouTube channel. So what I'd like to ask is, if you are new to the podcast, or you're a regular to the podcast and you haven't subscribed yet, I'd be grateful if you could head over to YouTube and subscribe to our YouTube channel. If you just search Real Employment Law Advice, you'll find it on there. The reason I'm asking you to subscribe now is because we have a series of videos coming up shortly, which I think you will find helpful and informative and hopefully a bit of entertainment as well. So if you could go over there, I'd be really grateful. In this week's episode of the podcast, I'm going to be covering off a couple of questions that have been arising quite a lot recently, both in terms of employers and employees. So hopefully you'll find it useful. And of course, if you have any questions about the content, then do not hesitate to get in touch with myself or one of my team. Our direct number is 01983 897 003. Many thanks for listening, and I hope you enjoy this week's featured content. So the first question I'm going to tackle for you today is one that I've been getting a lot of calls about in the last week or so. At the time of recording this, it's the 29th of March 2021, and today is the first real change in the lockdown restrictions. Namely, there's no longer the requirement to stay at home, and you are now able to meet up with up to 6 people or 2 households in an outside setting like a garden. And because of this, and also the impending further changes to the lockdown rules that are coming on the 12th of April, a number of businesses are looking at making changes to the way they work, either because of logistically or because they need more people in the workplace. And as a result of more people asking staff to either return to the office having been working at home or returning to work following a period of furlough, we're getting a lot of questions from employers and employees about those people who are reluctant to return to the workplace for a variety of reasons, but mostly they seem to be around the health and safety of the individual or the health and safety of someone that the individual employee is living with or caring for. So where you've got somebody who is reluctant to return, what are your options and what should you be doing? Now, the first thing to note, as always, is the most important thing when you have a situation where somebody is uncertain or anxious about returning is communication. You need to communicate with them exactly why you want them to return to the workplace or return to work, and what steps you have taken or are taking to mitigate any risk of them contracting coronavirus. And that can be in the form of a conversation, which it should start with a conversation. This is what's happening and this is why it's happening. And then followed up in writing with the paperwork to reassure them. So updating your risk assessment and providing a copy to the individual. And if necessary, setting out in writing the steps that you're taking to mitigate the risk to that particular individual. This is particularly important if you have somebody who is fearful for their own safety for whatever reason. Maybe they have an underlying condition or they're just overly anxious about the whole thing and you need to reassure them. Or if they live with someone who may have been shielding or who is vulnerable and they're concerned about them. So set out in writing exactly what steps you're taking to help them to ease them back into work. If the individual still says that they're concerned about returning to work, or in the worst case, they refuse to return to work, then you need to look at what the next steps can be. Now, my advice here is not to rush into a disciplinary process with them. I've seen some advice around about failing to follow a legitimate instruction and doing those sorts of allegations against an individual in a disciplinary process. Now, in my view, that's not going to help you at all. It's not going to help you to get that person back into the workplace. And it could potentially raise issues, not only in terms of legal risks, but also in terms of reputational. If you're the employer who's forcing someone down a disciplinary route because the employee is afraid of their own safety or someone they live with, you don't want to be that employer. You don't want to be that employer that's named and shamed in your local paper for putting someone in a disciplinary situation. As I said earlier, I always advocate trying to resolve things by discussion and trying to reach some form of compromise. Now, if a compromise can't be reached and the individual still refuses to return to work, then my advice is to explain to them that the only other option available then is for them to take unpaid leave. You can say, well, in that case, if we feel that we have fulfilled all of our obligations in terms of health and safety, we feel that we have reduced and minimised the risk completely, we've tried to compromise with you. And then as a final thing, we understand why you may be concerned, but we can't have you off work indefinitely on furlough when we've got work for you, or we can't have you working from home anymore because of X, Y, and Z. So we will grant you a period of unpaid leave. In my view, once you've gone through all those steps, that's a good compromise. If you really need them in the workplace, they can't work from home, then I would recommend that you offer them a period of unpaid leave until such times as they feel that they're ready to return to work. And if you do have an employee who accepts this offer of unpaid leave, then I would put it conditional on you reviewing it every 2 to 3 weeks with them as the situation with COVID evolves and the risks in society generally, and obviously keep revisiting your risk assessments. Now, you might be saying, well, that's all very well and good, Alison, but why can't we discipline or dismiss somebody who is refusing to work? Surely we should be able to tell them that they have to return and then they should just return. Well, you can certainly try that route. And as I say, they may present you with reputational issues if the employee goes to the local paper or if someone leaks a story that you're going through disciplinary processes with staff who don't want to return. But there are also legal risks because in some cases, workers do have additional rights not to be dismissed or treated detrimentally when they raise health and safety concerns. Now, of course, the situation with COVID is something that hasn't been tested and hasn't been through case law. But it's likely, in my view, that if you do go down that route with somebody who says they don't want to return for health and safety reasons, you could find yourself in difficulty if they were to make a claim against you for detrimental treatment or for dismissal if you took it that far. And as I said, I honestly don't think you're going to get the best result out of someone by forcing them to return with the threat of disciplinary action. It's always better, in my view, to use a carrot rather than a stick and to be the reasonable one in the situation than try to force their hand. And of course, it is an evolving situation. And as more and more people are having their vaccine and as the shielding advice is changing, it is acknowledging within society generally that the risks around contracting COVID are reducing, and therefore, in my view, the risks are reducing within the workplace in the same way that they are within society. And certainly if you're taking steps and putting in place measures to protect employees, then you're going to be reducing the risk to them hugely. There are all kinds of things that you can do in addition to the kind of standard social distancing that was taking place before, because there is access now to the lateral flow testing. So you can have regular testing of staff. You can see how many people have had the vaccine and take various steps. So hopefully, as we move forward as a country out of lockdown, the number of people who have anxieties and who are anxious about returning to work will reduce, but acknowledging you will still have those. And I think in the initial stages, as we start to unlock now, you are likely to find that there are more people who are anxious about returning to normal life than there will be in a few months' time, for example. Of course, if you want any advice about this on a case-by-case basis, I recommend that you seek advice because everybody's situation is different. So we're very happy to have a chat with you, and you can contact any member of the team for advice on the normal contact details, or you can email alison@realemploymentlawsadvice.co.uk. Now, the second big question that we're being asked about, and which I think it's useful that you're aware of at this stage, is what to do with those staff who have been shielding. Now, as I said earlier, and as I'm sure you're aware, from the 1st of April, the government guidance around shielding has changed. There is no longer the requirement for those who are clinically extremely vulnerable to shield. And as a result of this, those members of staff that have been shielding and who haven't been placed on furlough or who haven't been working from home will no longer qualify to be paid sick pay, statutory sick pay, during that time. So if you do have any members of staff who are shielding and who are in receipt of statutory sick pay, then they are no longer entitled to that from the 1st of April because they're being told to return to work if they're unable to work from home. Now, this may in itself present some issues, much like I was talking about earlier with people who are concerned about their own health and safety and those around them. And that's where I say, again, you've got to take into consideration the individual circumstances. Now, of course, it's very encouraging that the government are saying that they no longer need to shield, but that doesn't necessarily take away someone's own anxieties. So if they can work from home, then I recommend wherever possible that you continue to allow them to work from home for as long as they can. And you could also consider using the furlough scheme if you're unable to find a way for them safely to return to work. If it's your intention to bring somebody back into the workplace who has been at home shielding, again, I recommend that you start with a conversation with them. As you know, from the 1st of April, the government guidance around shielding has been changed, so you're no longer required to shield. As a result, we've been looking at the way that we work and trying to find ways to get you back into the workplace. These are the steps that we're taking internally to mitigate the risks to you, and would like to open up a dialogue to talk to you about any concerns you may have about returning to work. And start like that. And then, as I say, if you get to the point where somebody is saying to you, I'm extremely vulnerable and I'm afraid to return, you might not want to look at the situation where you're either offering them unpaid leave, or in a situation potentially where somebody has a disability, you might want to look at as a reasonable adjustment for them, putting them on furlough. So this is where I say it does very much depend on the individual circumstances, the individual person's concerns, and what steps you can take to help them to alleviate those concerns and get back into work. In order to help you with bringing staff back, not only those that are worried about returning, but all staff, whether they've been on furlough or working at home, I have created a checklist that you can use to help you through this process and hopefully make it as smooth and easy as possible. Now, you can download a free copy of that on my website, which is realemploymentlawsadvice.co.uk, and it's /DIY-documents, and there you'll find the checklist for employees returning to work, and I'll also put a link in the show notes for this episode. So finally, just to recap, if you have staff who you're returning to work who are either anxious about returning because of themselves, someone they live with, or they are an previously shielding person who's now no longer required to shield, the best thing you can do is to have a discussion with them. Try to reach a compromise and try to get them back to work. It's going to be the best for you all round. You can, of course, consider disciplinary action and potentially dismissal if someone constantly refuses to return, but I would take a very cautious approach at this stage in things before you start down that route. Obviously, if in 3 months' time you still have an employee who is being wholly unreasonable and refusing to return to work, then you can look again at the possibility of going down the capability or disciplinary or dismissal route, and I would certainly recommend you seek some advice at that time. But for now, as a compromise for employees who don't want to return, you can offer them unpaid leave, or if there's somebody who is a previous shielder who has a disability, for example, a reasonable adjustment may be to put them on furlough if you can do so. If you have any questions about this or anything else that we've talked about, furlough related or anything to do with employment law, then myself and my team are very happy to answer your questions. Please do not hesitate to get in touch. And of course, finally, please don't forget to go over to our YouTube channel and subscribe to the Real Employment Law Advice channel for more information and updates that will be coming to you very regularly in the near future. Thanks again for listening. I hope that you have a great Easter weekend, and I look forward to bringing you another episode in 2 weeks' time. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.